Sometimes the shareholders of UK companies prefer to remain anonymous. In these cases, institutions like Jordan's Trust Company can provide nominee shareholders to protect the identities of the ultimate owners of the company's shares. These arrangements are now being targeted by the government in the form of a bill called the Small Business, Enterprise and Employment Bill. What are the implications for this bill for investors in UK companies who would prefer to remain anonymous? So what will this mean for shareholders requiring confidentiality if this bill becomes law? Over the next few minutes, we will look at the detail of the bill a little more closely. The bill proposes that persons with significant control of a UK company, or PSCs, should have their personal particulars, including their names and nationalities, entered on a PSC register which would be maintained by the company and open to public scrutiny. If the PSC of the UK company is another company, whether UK or foreign registered, the bill requires that you drill through all intermediate companies until you arrive at a human being who exercises or is able to control the exercise of significant control of the UK company. There are two alternative reporting regimes. The default regime requires the UK company to maintain an up-to-date PSC register which contains the latest particulars of the PSC at any given time. This PSC register would normally be kept available for inspection at the company's registered office, and it must be open to the inspection of any person. Any person may also ask for a copy of the register. However, the inspection and copying rights of the public are not unconditional under the default regime. The person requesting inspection or copies of the register must provide to the requested UK company his or her name and address, the purpose for which the information is to be used, and if the information is to be disclosed to another person, the name and address of that other person and the purpose for which the information is to be used. A UK company receiving a request for inspection or copies of its PSC register must then either comply with the request within 5 working days or apply to the UK courts to seek an order to refuse the inspection or copying request on the grounds that the inspection or copy is not sought for a proper purpose. If the UK company fails to secure an order from the court to deny the information, it must disclose the information on the PSC register without further delay. The alternative disclosure regime enables the UK company to elect that the Registrar of Companies will maintain a central PSC register at Companies House. In this case, the UK company must ensure that the entries in the central register contain up-to-date particulars of its PSCs. Any person can search the central register maintained at Companies House at will, without providing any reasons for the request or their identities to the company. Even if a UK company elects to keep its own PSC register so that it can act as a gatekeeper of search requests, it must also file the particulars of its PSC or PSCs on the central register kept by the registrar on incorporation and annually. This draft legislation is undoubtedly a potential deterrent to the use of UK companies by investors requiring confidentiality. There is also the formidable detail of the bill, which poses significant burdens on both companies to investigate who their PSCs are and on the PSCs themselves, who have duties to report themselves to the UK company, and there are potential criminal penalties for both parties for non-compliance with the proposed terms of the bill. But that said, legitimate clients who want to invest in UK companies through nominee shareholders shouldn't necessarily despair at the prospects of this bill. The first point to make is that this bill may run out of legislative time. Parliament dissolves on the 30th of March 2015 in anticipation of the general election, which is going to be held on the 7th of May 2015. Currently, the bill has yet to go before the Standing Committee in the House of Commons, and then it has to be passed to the House of Lords. So the government are operating under a very tight timescale if they want to bring this bill into law before Parliament dissolves. Assuming the bill receives royal assent in the life of this Parliament, we're currently advised that the enactment of the legislation wouldn't take place until early 2016. Secondly, there is a lot that we can do quite legitimately to structure the ownership and control of UK companies to keep beneficial owners or ultimate shareholders requiring confidentiality off the proposed public PSC register. To illustrate some possibilities, firstly, we need to consider the statutory conditions for being a PSC. There are 5 alternative conditions, and meeting any one of these conditions will result in a person being potentially subject to disclosure. The first 2 conditions are that X holds, either directly or indirectly, more than 25% of the shares, that's condition 1, or voting rights, that's condition 2, in a UK company. So, if the shares and voting rights in a UK company are issued in equal proportions to 4 or more persons, no one is a PSC and no one would appear as a PSC in the PSC register. The third condition for PSC status is the entitlement, directly or indirectly, to appoint or remove a majority of the board of directors of the UK company. A shareholder owning no more than 25% of the voting power in a UK company is not a PSC under this condition, nor under the first 2 conditions I've just mentioned. The fourth condition is currently circular. If X has the right to exercise or actually exercises significant influence or control over a UK company, then X is considered to be a person with significant control. The government must publish guidance on this condition to comply with the terms of the bill in the form of regulations. So far, no guidance has been issued. But I would stress that if you are not a PSC under the specific conditions I've mentioned, conditions 1 to 3, it seems to me very doubtful that you can be a PSC under the 4th broader condition. There is also a solution to all these first 4 conditions, and that is trust ownership. If a UK or offshore trust is created to own the shares of the UK company, and the trust is discretionary in form, then the beneficiaries of the trust cannot be PSCs, and one discloses the trustees in their official capacity as the PSCs. Indeed, the government have already conceded that this will normally be the case in a published response to consultation on this draft legislation. However, if we do use trusts to own UK company shares in order to address the problems of the PSC register, we will have to watch the 5th and final condition for PSC status. Broadly, this says that if the trustees of a trust exercise significant control over the UK company under any of the 4 tests I've just mentioned, and another person, say a settlor, has the right to exercise or actually exercises significant influence or control over the activities of the trust, then that person is a PSC. However, if the trust is discretionary in form and managed and controlled by professional trustees according to current theories of good trustee governance, then it's very difficult to see how a settlor or a discretionary beneficiary can exercise control or influence over the activities of the trust. So trusts do offer a clear solution to the problems posed by the PSC register. Another potential antidote lies with share option agreements. If X, a would-be PSC, is prepared to set up a company in the UK so that its shares are held by shareholder Y, but with an option for X to call for the shares on or after a date specified in the future, then UK case law suggests that Y, and not X, is the beneficial owner of the shares prior to the specified date. If Y is able to exercise the normal fruits of ownership of the shares, then Y should be regarded as the PSC and not X. Another answer to the problems posed by the PSC register would be to issue different classes of shares in a UK company, with voting shares being held by PSCs who are quite happy for their control to be published to the world. If the shares giving economic rights represent no more than 25% of the issued capital of the UK company, then the beneficiary of these economic rights is not a PSC according to the terms of the bill, and so can be protected via nominee shareholding arrangements. This videocast can only give a snapshot of the bill's proposals, but I hope what I have shown is that with appropriate planning and foresight, it should be possible to protect legitimate investors from public disclosure under the bill's provisions through appropriate structuring of shareholdings in UK companies. Should this bill be seen in a negative light? It's true that there are many unsatisfactory aspects to the bill which I pointed out, but the fact is that UK companies are entrenched in international business and commerce. They've been widely used for more than 40 years now for their tax and other advantages. UK corporation tax rates are falling, and our corporate tax system has been deliberately redesigned over the last few years to attract foreign capital and foreign investment. So, perversely, the transparency provisions in this bill may add further lustre to the reputation of the UK.